All right, good morning, everyone. Our next panel will be on practical warrant attacks, and we've brought the big guns to talk to you all about how to challenge a warrant. First, we've got Justice Breese Davies. Justice Davies is a judge of the Toronto Superior Court of Justice since 2018. Before her appointment, she practiced criminal, constitutional, and administrative law at both the trial and appellate level. She is now an adjunct professor at U of T Law School and co-chair of OGEN. And of course, before her appointment, she was an extremely active member of the Criminal Lawyers Association, including as one of our vice presidents. Next, we have Leora Shemesh, who is the principal lawyer at Leora Shemesh Criminal Law, and Sonya Shikhman, who is a partner at Bytensky Shikhman. These two women, I'm going to introduce them together, are powerhouse defense lawyers who are well known for regularly bringing warrant challenges, including complex and novel challenges and very creative challenges. And they are both similarly passionate about holding the state to account. We're going to learn a lot from them this morning. Thank you.
All right, I'm going to start. Oh, there's perfect. Okay. So, good morning. Thank you so much for having me back. It's a bit of deja vu from many years ago, being here on the Friday morning for the conference. I'm going to just start off. We're hoping that this panel is going to be really focused on the practicality of how to challenge a warrant, but I'm going to start off with a sort of whirlwind overview of the law on challenging search warrants, just to sort of make sure we're all in the right frame of mind. So the starting point in terms of challenging a warrant, this closer to me, sorry. Do it that way, is that better? Okay. So the starting point for challenging a warrant is knowing what the police are required to put in an ITO. So the ITO obviously must articulate reasonable and probable grounds to believe that an offense has been committed and that evidence of the offense will be found in the location or locations to be searched. Obviously, if it's a wiretap, they also have to include they have to also address the issue of investigative necessity. It must contain full, fair, and frank disclosure because it's an ex parte application. It can include hearsay information from other officers, part of the investigation. It can obviously include information about confidential informants or other sources, and if it does, there has to be information in the warrant that speaks to the credibility of the source and what steps were taken to corroborate it. Obviously, there'll be an issue about how compelling the information is on a review. The police cannot, or on a review, there will be an application to excise information that was obtained as a result of a charter violation, another charter violation, and the police can't use boilerplate language. That's all the case law about what needs to be included. On a review, the starting point is that the wiretap or the search warrant authorization will be presumed to be valid, so the onus will be on you to overcome that presumption. The standard of review is quite high on an application to quash a warrant or an application under Section 24.2 to exclude evidence on the basis of a Section 8 breach. The test is going to be whether the judge acting reasonably could have been satisfied that the criteria for the issuance of the warrant were met, and if those criteria are met, then the warrant will be deemed to be valid or will be found to be valid. So it is a high threshold, which you need to keep in mind when you're preparing and thinking about whether you're going to bring a challenge. Obviously, there are two types of attacks. Facial validity is just an attack on the sufficiency of the information in the warrant. It accepts the information in the warrant as reliable and accurate, and the argument is that it does not disclose sufficient grounds to meet the statutory criteria. Subfacial attack is obviously one that attacks the content of the ITO as either unreliable, inaccurate, incomplete. If there's a subfacial attack, there may obviously be applications to amplify the record by the Crown, or the defense may seek to excise information that is either unlawfully obtained or inaccurate. On a subfacial attack, obviously the argument is that the ITO, even if you read it as a whole, it may sound like it discloses sufficient grounds, but the argument on a subfacial attack is that the information in the ITO is unreliable, incomplete, or inaccurate. Remember, there's no right to cross-examine the affiant or any sub-affiants on a Section 8 application. The onus is on the defense to meet the test for obtaining leave to cross-examine an affiant or a sub-affiant. Again, the test is quite high. The test is that cross-examination will elicit testimony tending to discredit the existence of one of the statutory preconditions. That's set out in Pierce and Lysing, which obviously upheld that requirement for leave. The focus of an application for leave to cross, or the focus of the cross-examination, should really be on errors, omissions, and misleading statements, or particularly when they relate to the reliability or credibility of a CI, if information is not there or information is misleading. Of course, any cross-examination or any challenge has to be based on what was known or ought to have been known to the affiant at the time the ITO was drafted. Of course, information can be gathered after the warrant is executed that would change the information in the ITO, but information obtained after the ITO has been submitted and the warrant has been executed won't be of use to you unless you can determine that it ought to have been known to the police at the time they drafted it. And again, the focus really has to be on undermining the statutory preconditions for the issuance of the warrant. I really encourage you, and we'll talk about this more throughout the panel, to really ask yourself, should you apply for leave to cross-examine when you're bringing a Section 8 application? Ask yourself whether or not you can make the argument just as well, or maybe even better, just relying on what you have in the disclosure to show that there are errors, or there are omissions, or there are misleading statements. Sorry, there's a typo in the slide, but you also have to ask yourself whether asking for cross-examination, and if you're given cross-examination, will that just give the Crown, through the officer, an opportunity to explain away problems or to explain away errors and to make them seem much more minor than they might be if you just have the disclosure. And also you want to ask yourself really whether you can narrow the scope of the cross-examination. Obviously, if you're into a warrant that has confidential informants in it, like the example that's in the materials and like many that I know you've all seen, you're going to have to go through the 6 steps of Garofoli. The first 4 really are about the editing process and the role of the court in the editing process and the preparation of a judicial summary of the information that has been edited out. Step 4 is the final edited ITO and judicial summary, which have been approved by the court, are released to the defense. And then you all know steps 5 and 6. Step 5 is if the warrant, which has been redacted, can be upheld as redacted, then you'll argue it on that basis, and the application, if it can be upheld, will be dismissed on that basis. If, of course, it can't be upheld on the basis of the redacted ITO, the Crown can apply to rely on as much information as is necessary in the redacted information, which you don't get access to uphold the warrant. And, of course, that can only happen if the defense has sufficient information through the judicial summary to be able to make meaningful submissions or to meaningfully adduce evidence on the application. So none of that, I'm sure, is news to any of you, but we wanted to make sure that we've got the framework out there for how to do one of these before I turn it over to Leora to talk about how she prepares for one of these applications.
All right, so how to prepare. I guess this is sort of the nuts and bolts about how we prepare a search warrant challenge. And I know that this is trite, but I'm going to say it. You need to read the entire warrant. You actually need to take the time and read every page, every line, every word of the document. I typically read through it once without really taking any notes at all, and then I read through it a second time. And the second time that I read through it, I begin to take notes on each page of the things that really spark my curiosity. So the first few pages of a warrant, I know for some may seem like the first few pages of a novel. People tend to sort of gloss over those pages and believe that they are irrelevant or that they're not all that seminal, but they are. And I pay careful attention to the officer who swore the information to obtain. And I ask, is he experienced? Has he indicated what his experience is? Is he knowledgeable? What is his background? And in the case that you've been given, hopefully everyone's had an opportunity to review it, the officer's experience dates back to 2006. He is a detective constable, but he was assigned to the Drug Enforcement Unit in 2023. So I take a note of that. Not a significant amount of time, and in this case, he indicates that he's also the lead investigator and the affiant. And I note that. I take a note of that. I think that's important, and it's important because as the lead, he's likely in a position where he knows much of the ins and outs of the surveillance and the finer details of the actual case. Later at paragraph 21, he indicates that he's completed a recognized investigation training course, including the Toronto Police Service's General Investigation Technique course, confidential informants, and a search warrant course. I take note of those things. I take note of them, and it's important to me, again, as to his background. Then he goes on to discuss what he has reviewed. And he indicates that he's reviewed the following items. He's spoken to officers, he's reviewed police files, notes, and investigation reports, and he's made inquiries through computer databanks and the internet. At page 5, he highlights the investigative sources, including what they are. And we know all of these, and we've seen them often. CPIC, Versadex, ICAD, so on and so forth. These sources become quite important to me because I want to see whether the affiant refers to all of those sources throughout the number of pages that he swears to. And I want to double check and see whether I have those sources. And so next, I want to know where the officer is seeking to execute this warrant. So the locations are obviously always very relevant and important to us. And I want to highlight and flag to myself so that I can understand really what are the grounds in the warrant for each of those locations, and have they been expressly articulated by the affiant. So sometimes the police use the same warrant for different locations, sometimes they don't. So be aware of the locations, note them down, and then I begin to really chart what falls under the house, the car, the hotel, and the conference center. Does the affiant have the grounds for each of those locations? And you'll note at paragraph 5 of this ITO that you've been provided that the affiant highlights that he believes that the items he's looking for are at the Toronto Marriott Eaton Centre conference room and the hotel room 1358. Strangely, he did not say in that paragraph that there are reasonable grounds to believe that the things listed are in the places detailed on page 3, like the hotel, her home, and her law office. So again, that's important. I jot it down. I keep track of it. Finally, I then highlight for myself the items that the affiant is actually looking for. So what is he looking for in this application? And we know in this case it was cocaine, proceeds of crime, drug paraphernalia, and a black duffel bag. So now the real work begins. Now we have our framework, and now it becomes quite technical. Now you begin to really dig for clues. You're digging for items in the document itself. You're digging for items in your disclosure. And you should have all of those items. And if you don't, you need to get them or request them. So now you need to determine whether you are missing pieces of this puzzle. And as I work through the document, I pay very close attention to the language. So is the language deliberately vague? Is it detailed? Is it precise? Is it broad? Those are things that you need to pay very close attention to. Has he exaggerated certain aspects of this warrant? And once I go through page by page, I then place, and this is just my style, I place a check mark on the page to remind myself that I've been over that page, I've checked all those sources, that page is done, and I move to the next page. I've satisfied myself that I have found all of the necessary sources, clues, underlying documents, and notes for that particular page, and I move on. If I feel I am missing any item at all on that page, doesn't get a check mark, go back to it and determine what I'm missing. We learn in this case that there are 2 confidential informants, and I ensure that I have a summary of the information associated to those informants, and I really do leave the confidential informant part of the warrant challenge to the end. It's to the end of my preparation. The body of the warrant for me becomes quite critical, and I leave the confidential informants to the end, unless, of course, it's heavily relying on the confidential informants. But the body of the warrant in this case has a lot to go through. And if you've had a chance to go through it, you'll note that there are certain parts of this warrant where you should be double checking with your disclosure that it does make sense and that it does align with the disclosure that you have. So there's an indication, for instance, that Elwoods was stopped and investigated. Ask yourself, do I have that occurrence? If not, ask for it. Do we have the notes from that stop, or is the occurrence enough? Are you content to rely on the occurrence, or do you want more information from the notes of the officers? I get it all. I don't just rely on the occurrence. I ask for all of the notes too. I want to make sure that the occurrence actually reflects and accurately reflects the interaction with the officers. Similarly, on the same page, there's an indication about an MTO database. Ask yourself, do I have that? Do I have the MTO database? I cannot tell you the number of times that I have asked for the MTO documents, and they are not what they are purported to have been indicated in the warrant. Sometimes there is more than one address that's articulated. Sometimes the address is dated, and there's a more current address that the affiant has deliberately omitted. Sometimes there's cellular numbers there that are different than the cellular number that they're actually trying to obtain access to. And so the document itself, if you don't ask for it, you don't know about it. And so I implore you to please, if you have references to certain documents that the affiant is relying on, get them, double check them. There's no harm in doing that. I send disclosure requests, obviously, and indicate that as I'm going through my preparation to make sure that I have it. If I don't have it, I continue to hound the Crown for that disclosure. Then we move to surveillance, a very important aspect of a warrant application. Again, I can't tell you the number of times that I have surveillance reports that are not accurately reflected in the affidavit. And so I encourage you to get those surveillance reports, review them yourself, and make sure that the underlying sources are accurately reflected. The affiant relies on surveillance that is often conducted by many police officers, as you know, and those surveillance reports are traditionally provided by the Crown, and the reports are helpful, but they're not the be-all and end-all. I'd ask you to look at the underlying notes of the officers to make sure that the surveillance reports accurately reflect the observations that were made by the officers. And then I want to compare the surveillance reports to the number of officers who are referred to in the report itself. Do I have them all? If I don't, obviously ask for it. I pay careful attention to time. Time is very important, so are locations and actual observations. Ask yourself, has the affiant exaggerated any of the observations that were made? Has he omitted information, and or has he modified the information? Review the notes carefully, cross-referencing, of course, the dates and the times. You'll note in the affidavit you've been provided, for instance, at page 10, that there are time references of 1430 and 1830. There's nothing about what happened in between. So ask yourself, what took place in between, and is that relevant to my case? Why am I missing a chunk of time in the affidavit, and is any of that relevant or helpful to my charter challenge? Did the affiant omit things that, of course, would have helped your client and are just simply omitted to assist the officer in obtaining the warrant? And were there other observations that should have been referred to? Innocent observations that, of course, been left out. The affiant refers to CCTV footage. Do I have it? Have you watched it? Please, if you're receiving CCTV footage, don't just assume that what is indicated in the affidavit is accurate. Review the CCTV footage on your own. Make sure you have it. If you don't, seek it. Don't just assume that if the affiant essentially refers to a piece of evidence that he has done so accurately. It's your job to review it and ensure that it is accurate, and it's your job to ensure that you have it. I don't know how much time I have left. At page 13, finally, I'll just move quickly. The home office and the car and her vehicle, the officer or the affiant says, are safe bases for L. Wood's criminal enterprise. Ask yourself, where does he get that from? Is it grounded in any of the evidence that you have? Make a note of it. This is something you may want to highlight for the reviewing judge when you are in court. Preparing to challenge a search warrant can really only occur when you know your case inside and out. You need to know the disclosure. It is not enough to simply rely on the affidavit and the notes of the affiant. It is important that you go through meticulously your disclosure before you even turn your attention to the affidavit, and then you need to go back and forth and cross-reference. It should be seen as a meticulous job and a very technical job. Finally, and it's a good lead up, I think, to Sonya's role on the panel, is the confidential informant information. Obviously, go through the summary that you've been provided. I won't go through how to challenge that. I'll leave that for Sonya. But let me say this, I haven't yet had a warrant that I can review, put it aside and say it was a wonderful warrant. There is always something in that document for you to go through and challenge, either facially or subfacially.
So I want to talk about what happens if you do get that perfect warrant. You did all this work that Leora tells us to do, and then it just looks great. What do you do? So, cause some havoc. So let's talk about that. I call it the last resort, the very long journey to victory. Now, before you go on this very long journey, you must make sure that you rule out the big four. Make sure they did not steal anything from your client. Make sure they did not beat up your client. Make sure that they did not violate the client's right to a speedy bail hearing. And then make sure there are no inconsistencies, everything matches up. You've done all this work, but the dealer's showing an ace. What do you do then? Oh, and one more thing, the Crown's not going to step 6. What? So this is the big thing. The Crown's not going to step 6 because they have 5 observations that are hand-to-hand in open daylight, and they've got 17 officers seeing it and taking pictures. What do? It's pretty good warrant, right? Like, it looks pretty good. And I see him going back and forth, like in the wire, into the stash house and doing a hand-to-hand. Like that's pretty much the end. So what do you do? So I have 3 kind of things I want to talk to you about. Ask for more disclosure. What do I mean for more disclosure? Not the kind of disclosure that Leora talked about, but the kind of disclosure which is, thank you, Mr. Nathan Gorham, for this wonderful case of Regina and Mackenzie. Ask for stuff behind that goes to issues behind the black. Ask for appendices. Ask for anything and everything in the investigative file. Now, what happens if they tell you, well, we're not going to step 6, so why do you want it? No, that's not how this works. I am entitled to it, you give it to me, and then we'll figure it out. So look up this case. It has a lot of very helpful excerpts about what you do and about all the 3 things I talk about, but ask for things. The more you ask for, the more you complicate the Crown's job, the more you can figure out, and the better it may be. Well, at least you'll have something or something to do or something to say. The next thing I want to talk about is step 2 and step 3. I mean, for the longest time, I thought there was only step 6. Apparently, there's 5 more steps before that. So what are those steps? Where do they start? What do you do? And it's an interesting question. So step 2 is what can be called, what I call, a sort of a reverse step 6. It's based, remember what I said, the Crown's not going to step 6, right? So the judge not going to see any of the unredacted material. But you've got nothing. Seemingly, you've got nothing to lose. So you tell the judge, can you look what's behind the black and tell me what's in there? So we fight so much, and I fought so often against the step 6 because the judge shouldn't see anything I don't see. But if I've got nothing, might as well. Maybe they'll find something and tell me about it. So that's step 2. What is step 2? How does it proceed? It proceeds very similarly to step 6. The judge gets an unredacted version of the ITO, and then they get into this hearing about what can we tell the defense counsel, not for the purposes of it being subsequently used as a way to defend the warrant, but for disclosure purposes. It's a significant, important distinction and that's outlined in Regina and Berger. It's got a different purpose, but an important one. But in essence, the judge engages in a very similar activity. Go to step 2, read the case. Ask for a Bassi hearing. Why not? Might as well throw that in there. It's a privilege the Crown has to prove. Make them prove it. Make them prove the privilege that, in fact, the informant was not acting under implicit or explicit direction of the police officers. Have an ex parte hearing. Make them prove it. Now, benefits of this attack. What may happen? I mean, are you actually going to discover something? Potentially. That may happen. It's yet to happen to me, but here's hoping. I'm back in court in half an hour. I'll let you know tomorrow. But what you may find is something to mount your residual discretion attack on. What does that mean? A subversion of the process. We've all heard about this impossible test to challenge the warrant. Could the warrant have issued? Well, of course it could have issued. It issued. So it's a different panel to talk about the test, but that's a high test. We all know that. There's a different way that's more akin to an abusive process. That's the residual attack, the subversiveness of the process. So basically, maybe something in that, after the step 2, jumps out at the judge that the police officers clearly misled the issuing justice about. Yes, the Crown's not going to step 6, and the warrant is seemingly defendable on its merits, but something behind the black is so dishonest that it may amount to an abusive process, and that may come out and allow you to mount that attack. The other thing you do, the more you ask for, the closer you get to the privilege, the more the Crown wants to resolve. It's a very difficult situation for the Crown to be in, and I'm rarely sympathetic to the Crowns, those of you who know me would attest, but this is one of those situations where it's really a hard job, because they are trying to, they're in the hot spot, they're in the hot seat. They want to do the right thing, they're told to do the right thing, and they're trying to do that while at the same time not mislead anybody, because they have professional obligations, while at the same time not accidentally disclose the privilege. And they have the police officers who are chirping at them like, don't you dare. And so it's a difficult job. So the more you ask for, the more pressure you apply, the more likely it is that you'll get some kind of resolution. Again, has not happened to us in this case, but again, here's hoping. So, and the last one, of course, 11B. This is an unreported decision. I mean, you have to be a little obnoxious to quote your own decisions, but here it is. The Crown sometimes take a very wrong views and very wrong positions. No, it's privileged, I'm not giving it to you. Tell me why that's privileged. I'm asking you for documents. Yes, they're privileged, but I'm entitled to it as part of the Mackenzie disclosure. You can black it all out, but start with giving it to me all blacked out. Then you can try to defend your privilege and we can talk about more. And sometimes the Crowns take very unbelievable positions about that because they just don't want to look at it. And then you bring in disclosure motions, you schedule them, you take the time, and then you pass the 18 months. Why? Because you've spent litigating, enormous time litigated motions that were unnecessary. If you're doing that, though, protect yourself up front, write a disclosure letter that's like a legal memo, that's like a factum, so that nobody can say that you haven't given the Crown every opportunity to do the right thing. Now, I told you about the benefits. This is a waiver of liability, and you must read this, okay? You only use the strategy if all else fails and the above four have been proven completely meritless. Side effects of the strategy include I can't read from there, so I'm gonna read from here. Side effects of the strategy include further reinforcing the warrant and the judge commenting on your role in it for your client to hear, providing harmful information about your client, swaying your trial judge against your client's defense on the merits, looking really stupid on appeal when new counsel spots an issue on the face of the warrant that you did not see that would have worked but won't work now that you've led all this harmful evidence. This will lead to blurred vision, self-loathing, and desire to quit this godforsaken profession once and for all and to join Elle Woods in her dangerous yet lucrative venture. Thank you. It was good.
So in the few minutes that we have left, I'm just going to give you a few of my observations, having now heard several search warrant challenges from the other side of the courtroom, and just give you 4 thoughts about what might be advice, might be helpful, I don't know. The one thing I would say, just picking up on what Sonya said right at the very end, is I think you really do need to ask yourself, after you've done all of the work to know whether there are errors, know whether there are omissions, know whether there's a possibility of attack, to really sit back and ask yourself whether or not the application has merit. Can you establish a Section 8 breach? Can you establish that the warrant wouldn't issue? Even if you can establish that the warrant wouldn't issue, can you establish a breach that would result in the exclusion of evidence? Obviously, you all know that you have an obligation to fearlessly raise any issue and advance any arguments, including novel arguments. I'm not just trying to discourage you from doing that. But of course, your obligation to do that does not extend to bringing meritless charter applications. Court resources are incredibly scarce. And so bringing meritless applications is not part of your obligation. And in fact, it doesn't help your client's cause. It can obviously adversely impact your client's rights. If it's found to be a meritless application, that could be used as defense delay on an 11B application, and it could undermine your reputation with the court, which is incredibly important if you're going to have a trial in the case that you're dealing with or in any other case. The second thing is more a plea than a piece of advice. Please maybe the rest of them are pleas instead of advice. Please be prepared to discuss your Section 8 applications in detail at the judicial pretrial. It's not enough to just say, yep, we're bringing a Section 8 application. You need to have done all of the work that Leora and Sonya have talked about before your judicial pretrial. You need to know whether it's a facial attack or a subfacial attack or both in the alternative. Are you seeking leave to cross-examine? Who? On what basis? Can you rely on disclosure? Can you do most of it on the basis, if you've had a prelim, on prelim transcripts? Is there a small amount of evidence you need to call? Can you do most of it on an agreed statement of fact if it's a narrow issue? You need to do all of that before your judicial pretrial so that the court can meaningfully assign time to your application and you don't end up in a situation where your pretrial motions are taking longer than you anticipated because you haven't properly prepared, and that causes havoc for everybody's schedule. The other thing that I wish I had done when I was a lawyer before I became a judge was think more like a judge when I was preparing. You all know at some point in time, if you bring a Section 8 application, a judge is going to have to write a decision about it. They're going to have, so you should anticipate what you want that decision to say. I mean, you don't get to write it, but you certainly should know what are the factual findings that the judge is going to have to make in your favor in order for you to be successful. What legal arguments is the judge going to have to accept for you to be successful? What are the difficult issues the judge is going to have to deal with in order for you to be successful? There's not a slam dunk Charter 8 application very often. There are going to be bad facts. There may be case law that's going to be difficult that you're going to have to try and distinguish. If you focus on the things that you know the judge will have to decide and help them work through the analysis, you're much more likely to be successful and persuasive. Prepare agreed statements of fact on issues that are not important. The last thing you want is for your judge to be sitting through a Section 8 application and through the evidence thinking, I have no idea how this is related to any argument that might be advanced. So if you can tell your judge up front, this is the issue, this is the focus, this is the law, this is the question you're going to have to ask, we're interested in the validity of the warrant in respect of this location, but not that location. All of that will allow your trial judge to listen to the evidence in a way that's helpful to you, listen to your argument, and focus you should also focus your written materials on the issues in dispute and only give case law that's relevant to the issues in dispute. Nobody wants 100 cases on all of the charter issues ever. We want your help to be able to make a fair determination of the case. The other thing is, if you do that work of sort of thinking like a judge, what is my judge, what facts are the judge going to have to find, what legal arguments are they going to have to accept, it will allow you to focus much more in the hearing. It'll focus your attention on what areas of cross do you actually need, if any. Oftentimes, you won't need to seek leave to cross-examine because you can do it on the basis of the disclosure. Of course, you're much more likely to get leave to cross-examine if you say, I have 2 discrete areas that I want to cross-examine on, the rest I can do on the basis of the disclosure, rather than what we most often see, which is a list of 17 areas that are totally generic, that was probably presented in every other application that the lawyer has brought that says why they omitted this and why they didn't do that and why they didn't deal with investigative necessity. If you just provide us with a generic list, we're much less likely to be convinced. And be upfront about what the issues are, identify them clearly, because you'll be much more persuasive if your judge knows exactly where you are going at the end of the day. And please, 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 I know it's tempting to sort of gloss over those difficult facts and the difficult case law because it's difficult, but your judge isn't going to be able to do that. And so they're going to have to deal with the difficult facts. They're going to have to deal with the case law that may tend to go against your argument. So if you can deal with those issues head on and give your judge your best argument about how to deal with the difficult facts, how to deal with the case law, you're much more likely to be persuasive. So I think those are my thoughts. We have 21 seconds left. I don't know if anybody has... But otherwise, thank you all very much.
Yes, a huge thank you on behalf of everyone to our panelists, and I'll invite Adam Weisberg up to introduce the next panel.